Good afternoon, everyone. So, I am from Group 2 and the assigned topic that Group 2 need to be discussed is the different kind of obligation, Chapter 3, Alternative Obligation. Article 1199, a person alternatively bound by different prestations shall completely perform one of them. So, ibig sabihin po, if may one person po na alternate na gaganap sa isang obligation, one of each prestations is kailangan niya pong i-perform as said in the law po na Article 1199. Kinds of obligation according to object. Number 1, simple obligation. One where there is only one prestation. So, dito po sa simple obligation, only one prestation lang po ang kailangang i-perform. So, for example po, D promised to deliver C a 2010 model BMW car. So, yung 2010 model BMW car po, yun po yung tinutukoy na only one prestation na kailangan i-deliver ni D kay C as said in the simple obligation po. Number 2, compound obligation. One, where there are two or more prestations. Under po ng compound obligation, A is the conjunctive obligation. One where there are several prestations and all of them are due. So, yung tinutukoy pong several prestations po doon is, for example po, D promised to deliver C a 2010 model BMW car and a dump truck. So, yung 2010 model BMW car and dump truck po is yung several prestations po na need po i-deliver ni D kay C as said in the conjunctive obligation. Next is distributive obligation. One where there are two or more prestations is due. It may be alternative or facultative. So, dito naman po sa distributive obligation, kagaya lang po siya ng conjunctive obligation, the only difference is only one or some prestations are due. So, ibig sabihin po, it depends na lang po sa kung ano po yung mapapag-usapan ng creditor at debtor na i-deliver at the exact time at kung ano lang po yung kailangan i-deliver. Meaning of alternative obligation. An alternative obligation is one wherein various prestations are due, but the performance of one of them is sufficiently determined by the choice which as general rule belongs to the debtor. So, ibig sabihin po, there are several prestations due to the creditor, but the performance by the debtor or any one of them of the prestations is sufficient compliance with the obligation. Like for example po, D promised to deliver C either a BMW car, a Jaguar, or a Mercedes-Benz. So, sa alternative obligation po, kung ano lang po yung available na pwedeng i-deliver, yun lang po yung pwedeng i-deliver ng creditor sa debtor as instead of the alternative obligation po.
Article 1200. The right of choice belongs to the debtor unless it has been expressly granted to the creditor. Right of choice is a rule given to debtor. As a general rule, the right to choose the prestation belongs to the debtor. By way of exception, it may be exercised by the creditor but only when expressly granted to him or by the third person when the right is given to him by common agreement. Example, D insured his house with R, an insurance company. It is agreed that if the house is destroyed or damaged, R may either pay the damage or loss or reinstate or rebuild the house, since nothing is said in the contract as to who has the right of choice. It belongs to R as debtor. Right of choice of debtor not absolute. The right of choice of the debtor is subject to limitations. The debtor cannot choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. These prestations are void. Their presence do not invalidate the obligation if it includes other undertakings otherwise free from such defects. In other words, under Article 1200, the debtor's right of choice is not extinguished altogether but limited to the remaining valid prestations. Second, the debtor has no more right of choice when among the prestations whereby he is alternatively bound, only one is practicable. In this case, there is not only a limitation but a loss of the right of choice belonging to the debtor. The obligations become simple. Lastly, the debtor cannot choose part of one prestation and part of another prestation.
Article 1201. The choice shall produce no effect except from the time it has been communicated. Communication of notice that choices has been made. 1. Effect of notice. Until the choice is made and communicated, the obligation remains alternative. A. Once the notice of the election has been given to the creditor, the obligation ceases to be alternative and becomes simple. B. Such choice, once properly made and communicated, is irrevocable and cannot, therefore, be renounced. The concurrence of the creditor to the choice is not required. C. Where the choice has been expressly given to the creditor, such choice shall likewise produce legal effects upon being communicated to the debtor. An obligation remains alternative from the date the promise was made. But when the debtor made the choice and communicated his choice to the creditor, from then, the obligation ceases to be alternative and it becomes a pure and simple obligation. This choice can be communicated orally or in writing because the law requires no form for communication. Proof and form of notice. The burden of proving that such communication has been made is upon him who made the choice. The law does not require any particular from regarding the giving of notice. It may therefore be made orally or in writing, expressly or impliedly. It is made by means of communication, whether it is orally. Promises that comes from mouth or must say promissory word, meeting of minds. When it comes writings or written proof, we have promissory notes, contract, and other written sources of proof or proofs.
Article 1202. The debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Effects when only one prestation is practicable. If more than one is practicable, it is Article 1200 that will apply. The obligation is still alternative because the debtor still retains the right of choice. Under Article 1202, if only one is practicable, the others have become impossible. The obligation is converted into a simple one. So, Article 1202. The question is when the debtor loses the right of choice. What is the effect when only one prestation is practicable? The answer is the obligation is converted into a simple obligation. So, may example po dito. Daniel promised Catherine to deliver his car or his house or 1 kilo shabu or star in the sky. So, yung choices 3 na 1 kilo shabu and choices 4 na star in the sky is illegal and impossible. Hindi na siya option. Now, nagkaroon ng earthquake, gumuho ang bahay at nasira. And that's before the choices 2, yung i-deliver yung house, was made. So, ang natitira na lamang ay yung car. Daniel deliver only one car. The Article 1202 provide in that case the debtor loses the right of choice. Wala na siyang choice. Ang ibibigay na lang ni Daniel is yung practicable. So meaning, the obligation is converted into a simple obligation.
Article 1203. If through the Creditors Act the debtor cannot make a choice according to the term of obligation, the latter may rescind the contract with damages. For example po, A is obliged to deliver B either a brand new Jeep or slightly used Corolla car. Since B likes the car, but the A has a right of choice, B tries to make sure that he gets the Corolla. So, since obligado nga po si A na mag-deliver either a brand new Jeep or slightly used Corolla car, and since gusto po ni B yung Corolla car but A has a right of choice, parang ginawan po ng paraan ni B na mapapunta sa kanya ang Corolla car. So, ang ginawa po niya, while pretending to the test drive the Jeep, he purposely causes diesel to be pumped into the tank, knowing that the vehicle uses unleaded. As a result, the engine breaks down. A would have no more choice but to deliver the only remaining object, and that is the Corolla. So, para pong ginawan po ng paraan ni B na mapunta sa kanya ang Corolla, and while test drive po, ang ginawa niya po sa Jeep na hindi naman po dapat pinakakargahan ng diesel, kinargahan niya, knowing that unleaded po yung dapat na pinapakarga sa isang jeepney po na kanyang itinetest drive. So dito po, under Article 1203, A has the power to rescind the contract and to ask indemnification for damages against B. So, si A po has the power to rescind the contract po. Since si B nga po is may ginawang kakaiba sa jeepney, may karapatan po siyang magbayad. May karapatan po si B na magbayad ng danyo sa kung ano man pong perwisyong nagawa niya sa kanyang tinest drive na jeepney. Article 1203 speaks of alternative obligation. Through the bad faith of the creditor, the debtor cannot make use of his right to choose the said debtor may rescind the contract with damages.
According to Article 1204, the creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation had been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. Note that this article applies when the right of choice belongs to the debtor. Effect of loss or becoming impossible of objects of obligation. Articles 1203 and 1204 apply when the right of choice belongs to the debtor. Under Article 1205, the creditor has the right to choose. Number 1. Some of the objects. If some of the objects of the obligation have been lost or have become impossible even through the fault of the debtor, the latter is not liable since he has the right of choice and the obligation can still be performed. This is an exemption to the general rule established in Article 1170 regarding liability for damages arising from negligence. It is somehow related from negligence before, but in this case, the obligation will still be performed. For example, Ada agreed to deliver item 1 or item 2 or item 3. If item 1 is lost through the fault of Ade, he can still select either item 2 or item 3. The loss of item 1 and 2 with or without the fault of Ade will reduce the obligation to a simple one. Number 2. All of the objects. If all of them have been lost or have become impossible through the debtor's fault, the creditor shall have a right to indemnity for damages since the obligation can no longer be complied with. Of course, if the cause of the loss is a fortuitous event, the obligation is extinguished. It is based by the fault of event that is present in the delay or loss of the obligation. If all of the items are lost through his fault, liability will attach. If through a fortuitous event, the obligation will be extinguished. Basis of indemnity. The indemnity shall be fixed, taking as basis the value of the last thing which disappeared or that of the service which last became impossible. In case of disagreement, it is incumbent upon the creditor to prove such value, or which thing last disappeared or which service last became impossible. Other damages may also be awarded. Indemnity is compensation for damages or loss. When it is used in the legal sense, indemnity may also refer to an exemption from liability for damages. For example, if items N2 are lost, Ada will be bound to deliver item 3. If subsequently item 3 is also lost through the fault of Ade, the basis for indemnity is the value of item 3 since Ade would have been found to deliver it had it not also been lost. The liability of Ade is not affected although the loss of items 1 and 2 was through a fortuitous event. If item 3 is lost without the fault of Ade, his obligation is extinguished and he shall not be liable for damages although the loss of items 1 and 2 was due to his fault. The reason is that after the loss of items 1 and 2, the obligation is converted into a simple one to deliver item 3. Ade cannot be held responsible for the loss of items 1 and 2 through his fault because having the right of choice, he was not bound to deliver either. The rule is just since he could have been liable for damages if item 3 instead was lost through his fault and items 1 and 2 through a fortuitous event.
And here is the Article 1200-05. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. When the right of choice belongs to the creditor, in alternative obligation, the right of choice, as a rule, belongs to the debtor. Nevertheless, the debtor may expressly give the right choice to the creditor. And here's the rules in case of loss before creditor has made the choice. 1. When a thing is lost through a fortuitous event. 2. When a thing is lost through debtor's fault. And 3. When all the things are lost through debtor's fault. Lastly, when all the things are lost of fortuitous event. And here's the rules applicable to our personal obligations. The above rules are also applicable to the personal obligations. The responsibility of the debtor for damage depends upon whether the cause which has rendered the obligation impossible was due to his fault or not.
Article 1206. When only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. Meaning of facultative obligation. A facultative obligation is one where only one prestation has been agreed upon, but the obligor may render another in substitution. Article 1206. Facultative obligations. Example, Daniel promised to give Catherine a car, but it was also stipulated that Daniel give his house as a substitute. In this obligation, only a car is due. Hindi kasama ang house dahil substitute lang naman yung house. Now, why is important to emphasize? Dahil ang obligation lang naman talaga ay magbigay ng car. Pag ang loss ng car through Daniel's fault will make him liable. Sabi nga po doon sa unang paragraph na the loss or deterioration of the thing included as a substitute through the negligence of the obligor does not render him liable. Meaning, ang pagkawala ng bagay na intended as a substitute, in my example, yung bahay ni Daniel dahil sa kanyang kapabayaan nawala o nasira yung house. It will not make it liable dahil nga substitute lang. Take note, this last sentence, but once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Sa sandaling nagkaroon ng substitution, hindi na car ang ibibigay at yung bahay na. Then the obligor is liable for the loss of that substitute if it's lost through his delay, negligence, or fraud. Effect of loss. Before substitution. If the principal thing is lost through a fortuitous event, the obligation is extinguished, otherwise, the debtor is liable for damages. The loss of the thing intended as a substitute with or without the fault of the debtor does not render him liable. Pag hindi pa nagkaroon ng substitution or before substitution, ang active prestation natin ay yung principal prestation. Debtor is liable if he is the cause of the loss of deterioration. Ibig sabihin, kapag nawala yung principal prestation natin before substitution, naging act ay yung fault ni debtor, nagiging liable siya for damages. Pero kung ang naging cause naman niya ay fortuitous event, walang problema. Fortuitous event, general rule, walang liabilities, walang liable. Number 2, after substitution. If the principal thing is the loss, the debtor is not liable whatever may be the cause of the loss, because it is no longer due. If the substitute is lost, the liability of the debtor depends upon whether or not the loss is due through his fault. So the debtor is not liable even if he is the cause of loss deterioration. So kapag nagkaroon na ng substitution yung principal prestation, hindi na ito yung active prestation dahil nagkaroon na ng substitution. Pag nagkaroon na ng substitution, nag-active prestation na natin ay yung substitute. So kung ano man ang nangyari doon sa dating principal prestation natin, wala nang liable. Kahit pa ang naging cause ng loss ay let's say yung fault ni debtor, hindi na siya magiging liable. Ang mayroon na lang effects ay kung mayroong nangyari doon sa substitute, wherein nagkaroon na ng substitution.
So that's the presentation of our group presenting Article 1199 to 1206. Thank you for listening.